of birth control, contraception. At the time, the state of Connecticut made it a crime for married couples to use contraception. The thinking was, well, we want to encourage procreation. We want to discourage adultery. And if all these married couples can use contraception, well, they might go and have sex with someone else that's not their wife. And they might have children. We don't want to encourage that. So we're going to ban contraception, though people only have sex in the home. Okay, whatever. This law wasn't enforced, right? No one actually enforced it. It was a kind of a silly law. Okay? But it was a law. And the Supreme Court said this law was unconstitutional. But why? Let me show. I don't have the video handy. Sorry. The opinion was very bizarre, and they effectively said that the Bill of Rights creates certain spheres of liberty. They called it a right to privacy. Right. The word privacy is not in the Constitution. There's no right to privacy in the Constitution. But the court held that a law regulating married couples goes too far, because they have the right to privacy in the married bed. Okay, they have the right to privacy in the married bed. That justifies a law banning birth control. So about the next case, I'm sure you've actually heard it. Yeah.
I'm sorry, I did not read the facts of the case, but for this one in particular, if this was not an enforceable, or a law that was enforced by anyone, then there has to be some controversy.
What a good question. So this was not a case where the cop barred into a bedroom and took out being a common law. That was not this case. Instead, the director of Planned Parenthood was arrested. And this is what's called a test case. Another phrase where basically the director of Planned Parenthood said, I'm going to be doing this, please come arrest me. And they arrested him. They want to challenge this case. They want to challenge this law. In fact, as this case was being decided, the state legislature was basically repealing the law. So it was a completely pointless law. No one enforced it. But think about it. How the hell are you going to enforce a law on married couples using contraception? You can't. No one goes into the bedroom. I mean, it doesn't happen. So you have to go after the doctor who prescribes it. Make sense? Okay. So Griswold v. Connecticut 65 established this notion of a right to privacy of married couples in the bedroom. The next case expanded that right. That's a case you probably know the name of, Roe v. Wade, 1973. But instead of limiting privacy to the marital bedroom, it expanded it to a doctor's office or a medical facility where these procedures are performed. So it wasn't about a private bond between a husband and a wife. It was about some sort of privacy between a woman and her doctor. The basis of Roe v. Wade is substantive due process, which is the idea that the word liberty in the 14th Amendment has substance, has content. And that the state cannot deprive people of that liberty. And here it was the right to terminate a pregnancy. Now, Roe v. Wade, people don't actually know what it actually held. Did not hold that you have an absolute right to terminate a pregnancy. It created this sort of trimester framework. Pregnancies are 9 months, so you have 3 months, you have 3 months, you have 3 months. So during the first 3 months, the court held that basically the state can't do anything, right? The state cannot enact any laws to restrict abortion in the first 3 months. In months 4 through 6, the states can enact certain laws to protect the mother. For example, some sort of health conditions. And only in the last trimester can the state prohibit or regulate abortion to protect the life of the fetus, right? So it was a 3 month, 3 month, 3 month. And as the child gets older, gets closer to term, the state can enact more regulations to protect the fetal life. Okay? Roe was decided in 1973, and it declared unconstitutional effective laws in 43 out of 50 states. It was revolutionary, right? It changed overnight the laws in 43 states. In fact, many states were actually liberalizing their abortion laws before Roe. But Roe created a massive backlash because people say, what the hell is this? Who's the Supreme Court to do this? And the modern evangelical Christian movement largely grew in opposition to Roe. And to this day, abortion is extremely controversial in the United States. And I don't think this will change anytime soon. Whether Roe stays or goes, this issue is now front and center in our culture wars. Any questions on this?
But is abortion legal in state?
When and under what conditions? It depends. In some states like California, abortion is legal just about any time you want. And in fact, the state will subsidize it in some cases in some states. In other states, with some exceptions, abortion later on is very difficult. And the state passes laws to restrict what procedures can be done, at what juncture can the procedure be performed, and the laws vary significantly from state to state.
And if you go from one state to the other to have abortion and come back, can they
That's fine.
penalize you?
No penalty.
Because this is not what's going on in Europe. I mean, because for example, Poland, I'm from Poland, forbids abortion completely. I mean, there are like.
So would we just take a day trip to another country?
Yeah, some people go to Czech or to Austria, but of course they want to also kind of because you know we only do it when you know you're pregnant, and there are reasons, but you know in Poland they will not allow you even if the fetus is in this month or whatever. Yeah, so women want to go out. But then they want to penalize the doctor that he told her that this is a...
Oh, I see, to make a referral.
Yeah.
No, we don't have that. It's, people can travel if they need to.
Okay.
Yeah, the
I understand that those are one of the questions for the Supremes when they are candidates, when they should about abortion.
Yeah, so the question was, are the Supreme Court justices asked about this?
Yeah.
They're often asked, they don't answer. A judge cannot tell you how they'll rule in the case beforehand. If they say how they'll rule, they have to recuse. Makes sense, right? You can't give your judgment in advance. So they say, I can't give you a preview. No prints, no hints, no previews.
But in this situation, in any kind of situation, the Supreme Court doesn't understand that it would like, for example, California, that told that it's possible to do abortion. The Supreme Court will consider this kind of situation as something against life. Like for example, there is something that the Constitution takes care of.
Well, the abortion decision was 7-2 in Roe v. Wade. It was 7-2. The majority said that the 14th Amendment protects this, and the dissent said the 14th Amendment says nothing at all about abortion. It's silent. The decisions aren't whether you're pro-life or pro-choice. It's about how you understand the 14th Amendment's due process clause. But to be sure, there's a very strong overlap between those who are pro-life and those who see the 14th Amendment as imposing no limitations on abortion. So there's a strong overlap.
It says about any person,
Yeah.
when they're pregnant, if it's not, became a person on
Says who? Who says you're a person when you're born? Says who? So for example, I teach property law, maybe it's in your country. When you're in utero, you can actually inherit property. There are lots of instances where fetuses in utero can inherit property and have legal rights. If I murder a pregnant woman, I can charge with double homicide. So there are lots of instances where a person has legal rights before they're born. The Constitution is just a person. I mean, it's a hard question, right? To be a citizen, you have to be born. That much of it is clear. But you can be a person before you're born. This is a hard question. I don't intend to resolve it here, but it's not clear cut. And the court doesn't base your abortion rulings on when you're a person. They don't use that frame. They say, well, you might be a person, but there might be situations where it's justified. So, for example, I live in Texas, right? If someone breaks into my house, I can kill them, and there's really I'm going to walk away free, right? I'm taking a life, but it's self-defense. So there are instances where the law lets you take a life, and it's justified. And that's the sort of basis on which abortion law might be premised. I don't know what your self-defense laws are like in your country, but in our country, it's something called the castle doctrine, right? Where someone trespasses in your home, and I take their life, I'm walking home. Yeah. Things you learn. You didn't think you learned this in the intro to U.S. law, whatever the hell the name of this class is, right? Okay.
So,
Yeah.
just be sure that I understood. In California, you can do abortion at any time, and you do need a justification. Medical.
I am not an expert, but I think there are a couple states where you can basically get at any juncture, and maybe with a doctor's recommendation, but those are easy to get.
Yeah, it varies from state.
It varies. I mean, in some states, you know, you can get abortion. If the mother's life is in jeopardy, you can basically get abortion at any juncture. If the mother's health is in jeopardy, for example, if delivery might cause complications, it might be permissible. At a certain really late stage, like 38 or 39 weeks, I think at that point they'll just make you deliver it and give it for adoption, whatever. But I've read there are some clinics that will do it at the very end. They don't advertise they do this, but they do exist. It's a hard question, but in most states you cannot, but in some states it's permissible. 38, 39 weeks, you know, at that point it's basically done.
Well, there are some kind of tribes, I don't remember if it was South America or Africa, where basically you can kill your child until you don't give them the name. Because before you gave the name, they did not become the part of the community. So
I don't know.
I read about it and I thought that's weird.
I don't know. But you know, I don't know. Okay, let's move on. Now, here's the newsflash, right? Roe v. Wade was 73. Roe v. Wade is no longer the law of the land. In 1992, the court decided another abortion case from Pennsylvania called Planned Parenthood versus Casey, where the court basically got rid of Roe. They don't tell you that, but they got rid of Roe. Roe had this trimester framework, first, second, third. Casey said no more. Instead of drawing the line at first trimester, or second trimester, instead in Casey, they drew the line at viability. After viability, the state can basically do whatever they want with some limitations. Before viability, the state cannot impose obstacles to getting an abortion. Now you're gonna ask me, Josh, when is viability? The court didn't say. And you may say, Josh, wait a minute, isn't viability going to depend on science and whatever new developments in fetal care? Yeah. So whatever viability was in 1992, we're now 30 years later, it's different. Science improves. Neonatal care is stunning, but this decision was very difficult to apply, but that's our controlling law now. So before viability, the states cannot impose certain obstacles, what's called an undue burden. They cannot impose an obstacle before you obtain an abortion. After viability, the state has a lot more leeway to regulate abortion, but still protects for health and safety and other things. Okay, so Casey's actually our controlling law right now. Any questions on Casey? All right, next. Whole Woman's Health versus Hellerstedt is the court's most recent abortion decision. Okay, this is from not even 3 years ago, 2016. And it's from my state, Texas. Texas enacted a law to regulate abortion. And Texas says, if you provide abortions, you must be admitted to a hospital nearby. And if you provide abortions, you must have certain standards. You must be able to perform surgery in your facility. The problem is, a lot of abortion clinics in very small areas are remote. They're not near hospitals. And they don't perform surgical abortions, they perform abortions with medicine, different pharmaceuticals, right? So they said, look, we don't need to have surgical standards, we're not doing surgery. You give the pill and the girl goes home, right? Or we can't be admitted to a hospital because we're like in the middle of nowhere. There's some fairly remote regions in Texas. It's a very big state. And the Supreme Court said those laws were unconstitutional because they imposed a obstacle, an undue burden to obtaining an abortion, right? That women in those regions should be able to access these clinics. So this is the court's most recent statement on abortion from 2016. But the fifth vote in that case was Justice Kennedy. Justice Kennedy retired last year. He was replaced by Justice Kavanaugh, who was more conservative. This is another case that might get peeled back in due time. But even if these cases are peeled back, California can still have whatever abortion laws they want, and Texas will have the abortion laws they want. They'll basically allow divergence. So it won't be a nationwide change, but in about 20 or 25 states, I think you would see some changes. About half the states in the union. Yeah.
But, I'm not, familiar with what the issue is, but I've seen recently in the news that there is a lot of protests related to the restriction of this particular right. So if that is not based on a new case or a new ruling, then what's the?
A lot of states are enacting laws as test cases. In other words, they're enacting laws that they know are unconstitutional, hoping that the Supreme Court holds them. That the more conservative court might approve them.
Yeah, because of that change.
I mean, think of it right. I'll give you another example. It's not new. In Atkins, Children's Hospital, the court said you cannot have a minimum wage for women, right? In West Coast Hotel, they upheld the minimum wage for women. What happened? The state enacted it anyway, right? The state of Washington ignored Atkins and made their minimum wage for women. So it's actually not new that states enact laws that are directly in conflict with Supreme Court authority to set up a challenge to that Supreme Court authority. It's not new, it happens. So a lot of these states are enacting abortion laws they know are unconstitutional as a means to challenge it in court. They're just waiting to get sued. They want to get sued. And maybe they'll win, maybe they'll lose. Maybe there are 10 laws that are enacted and 9 are set aside and 1 survives, and that's the new precedent.
Michael, when you know that a law will become unconstitutional, we can submit something before.
To the court?
becomes a law. Yes.
We don't have that. Our courts do not give advisory opinions, right? You can't just present the law to a court and ask for an opinion. You have to basically enact it and wait to be sued. It's insane, right? And you have to wait to be sued in whatever court you want, and you have to go 2 years for litigation before you get an answer. Now, sometimes the court will put the law on hold while the litigation is proceeding, and sometimes they'll enjoin it and say, no, this law cannot go into effect while the appeals go forward.
We can make like a warning unconstitutional when that law, when they are going to apply the law to you.
Yep, no, you have to basically wait to be sued. You have to go, wait to be sued. Now, the way this works is as soon as Alabama enacts an abortion law, Planned Parenthood's in court in 5 minutes. They sue immediately. There's no delay. It's like, law goes into effect on Monday, lawsuit's filed on Monday. It's immediate. It's America. De Tocqueville, the great philosopher, said in America, all controversies go to the courts. He's still right.
On a very basic question, but who enacts the state rules?
Oh, we have state legislatures, right?
State
We have a governor signs it, and the state legislatures write the bills. Same.
Are you elected?
Yeah. Every state has their own legislature, and they enact their laws in the same way that Congress does. All right. 3 more cases, and I'll give you a break. These are the court's gay rights cases, right? I mentioned one earlier, Romer versus Evans from Colorado. The big one was 2003, Lawrence v. Texas from my hometown of Houston. There's a lot of Texas in Colorado. A lot, you know, this thing of having a lot of Texas cases. Texas, like most states, had laws banning sodomy, which is non-vaginal sex, if you will. Okay? But the Texas law was unique. It only applied to people of the same sex. So a husband and wife could engage in sodomy, it was fine, but 2 guys couldn't. In Houston, Texas, a guy named Lawrence was arrested. He was charged with having sex with another man. The case goes to the Supreme Court, and the court held that this law is unconstitutional, that you cannot intrude upon the dignity, the love between people. Now, Justice Kennedy loved the word dignity. That's a word you probably all love also. I know what the hell it means. But this was a concept that the word dignity and the concept of liberty protects people in their personal relationships, and the state has no interest to intrude upon private and intimate relations. So this was Lawrence v. Texas, 2003. It did not discuss gay marriage. It said we are not talking about gay marriage, but we all know it was, right? Because if you can't regulate homosexual relations, what they're doing privately, why can you tell them who they can and got married? So Lawrence was just a first decision. The next one was United States against Windsor from 2013. Congress enacted a law called DOMA, the Defense of Marriage Act. And what DOMA basically said was for federal law, marriage is one man and one woman, nothing else, right? That even if a state legalized gay marriage, federal law would not allow it. So let's say a husband and husband are married, New York recognizes their marriage, they file their tax return, they say they're married, IRS says, no, you're not married. So they cannot get the benefits for federal law of marriage. Supreme Court said, again, Justice Kennedy, DOMA is unconstitutional, right? That the state lacks a rational basis the state lacks a rational basis to deny these benefits to gay couples. Again, they did not say that states have to license gay marriage, but they said that the federal government cannot deny these benefits. The final case in the trilogy is a mouthful, Obergefell v. Hodges, in 2015. This case did involve gay marriage. And by a 5-4 vote, the court held that states are required to license gay marriage, right? And that the laws denying people the right to marry were based on animus or hatred towards gays and lesbians, and those laws were not permissible. So as a result of Obergefell, every state in the union was required to license same-sex marriages. And this was 2005, so fairly recent.
Every state in the union, sorry?
Yep, every state in the union had to license gay marriages, had to approve them.
Okay. Which are the benefits of federal law for marriage?
There are some. So for example, if you're married and your spouse dies, you don't have to pay the inheritance tax. If you're married, you file a joint tax return. If your spouse dies, you might get Social Security benefits. There's some benefits to being married, not a lot, but there's some.
Are just federal? You can have it in the state?
There's state benefits also.
Oh.
But Windsor, which was a case from 2013, is only concerned federal law, not state law.
Now, I'm asking because most of the requests or points out, like, for example, in my country, they present to go in favor of one same-sex marriage is because of the benefits of taxing, of Social Security and stuff. So now it's here, if it's allowed in the state, but if the federal is not Social Security,
No, Social Security is federal also here.
Okay.
Yeah.
So that's why the point, what they're pointing in Panama will not be valid here, even when the state is allowed, one of the state is allowed to have one-sex marriage, the Social Security and the stuff, they will have no benefits even when they are married.
Good point. All right, so Obergefell is 2015, and this was the court's most recent substantive due process case. Any other questions on Obergefell? We are right on time. We'll come back and do freedom of speech, right on schedule. All right, I'll see you all soon.
This one,